So thank you. My name is Joe Collenette, and I'm going to present this work which I completed with Katie and Trevor from the Department of Computer Science and Constantine from the Liverpool Law School. So just to give you a bit of an overview, I'm going to start off with an introduction to our work, including some of the motivation about why we've chosen admissibility of cases as the problem to tackle. I'll then discuss how our model was implemented, both as a concept and practically. And then finally, I'll discuss the pilot study where our implemented program was used by a small sample of lawyers who work in the European Court of Human Rights. And then finally, I'll take some questions at the end. So we've developed a model that determines admissibility of cases that are submitted to the European Court of Human Rights. Admissibility in this case is whether the court will look at that case. And then if it's not admissible, then they don't look at it. And once our model has determined whether a case is admissible, it explains how it came to that decision. This is then implemented into a Java program and then we've obviously conducted a pilot study where we've given our program to a small group of lawyers. So just a brief introduction on the European Court. It was established in 1959, and it makes judgments on whether a member state has breached the European Convention on Human Rights. Decisions are mostly based on previous cases, such as in case law, but there is no specific requirement for the court to follow that in practice. So we've chosen admissibility specifically rather than the outcome of cases, as this is a major issue that the lawyers that we've spoken to have identified. So to kind of show you the scope of the issue, in 2019, there were 45,500 applications, approximately, submitted to the European Court, but only 90% of these were declared inadmissible. Only a small proportion of cases actually get to a point where a judgment needs to be made. And there's currently 50,000 cases in the European Court's backlog. So being able to speed up the ability to decide admissibility would massively improve a person's access to justice in Europe. So our model has been implemented as an abstract dialectical framework, or an ADF, using the angelic methodology, which represents case law as a factor-based hierarchy. So you can represent this as a tree structure, and at the root node, you'll have a violation, and then you have some children, which are the issues, and then but the children of those issues would be the factors, which can be base level factors or abstract factors. And each node in this tree will have some acceptance conditions to say whether that abstract factor issue is accepted. So for the legal foundations of our model, we looked at admissibility, and to decide that, we need to know whether it's within the jurisdiction of the European Court, and the European Court has a set of formal rules that every application needs to meet. And these are things such as the application needs to be submitted within 6 months of the violation happening. It can't be a trivial case. And by trivial, there are some exceptions. And it's the same with anonymous applications. Normally, they don't accept them, but in some special cases, they may accept them. And there's a whole list of other rules as well. So here's our example of an implemented model. So at our root, we have the node V1 that represents whether a violation of admissibility has occurred. And this is accepted when the two issues I1 and I2 are also accepted. And then issue 1 is accepted when the two base level factors and two abstract factors are accepted. Base level factors are represented as questions which reveal a fact. Abstract factors can have other abstract factors or base level factors as their children. So this was all implemented in a Java interface, and it asks each of the questions from before, one after the other, until a decision can be made. Once the decision is made, it then gives gives the answer out, and it also gives the explanation as to why it came to that reasoning. And all questions are phrased as yes or no questions. So here's an example of what would happen at the end. So you get the decisions at the top, and then the explanations in the text box underneath. So in this example, the application won't be registered, and that's because the applicant doesn't have legal representation. The application form wasn't signed, so these would have been base level factors, so questions that would have been given, and we can infer through the issues that not all signatures have been provided, and that the application doesn't comply. Now, obviously, the ADF is a lot bigger, but we only when we generate our explanation, we only take the parts that the user have answered and is actually relevant to the decision that's made. So we don't just show everything in one go. So when we finished making this, we sent it off to 4 lawyers who work within the European Court of Human Rights. And once they had a play with the program, they completed a survey which had 11 multiple choice questions. And these questions, you could have a positive or negative result. So it's to strongly agree, disagree, strongly disagree. And these covered things such as functionality, usability, explainability. So whether the program functioned, how usable the program was, what they thought of the quality of the explanation, how useful they would find the program, and what they thought of the questions that we posed within our program. And so in our results, we had largely positive across the board, which was very nice to see, even though there's very few. And to conclude, so obviously we had some very positive results from the lawyers, and we can generally take away that lawyers do want technology to help them with the issues that they are facing. But they're also not computer experts, so we can't have anything that's too complicated or difficult to set up. So our future developments have tended to lean towards web-based systems. Okay, thank you very much for listening, and I'm happy to take any questions.
Okay, thank you very much, Mr. Collenette. It was a really good presentation, lovely.
Thank you.
And about the questions, when working with the experts, which you think were the main limitations to cooperate with them to do the work?
So when we created the questions, I first went through the booklet that they give to the lawyers to explain how admissibility works, and then I created a set of questions, and then I spoke to the lawyers about it. It generally went well. The biggest difficulty was finding things that weren't explained in the documentation that was given. So there was often hidden things. It's usually some exceptions to the questions that were given that needed to be added in. So it's usually trying to find little finicky parts of the law that, as a lawyer, you don't really understand.
Ah, okay, I get it. Another question is, this work was modeled, think about a case law judicial system, right?
Yeah.
Or so have you, okay?
So yeah, it is case law for the most part for the European Court, but they're not bound to it. So they will typically, in almost all cases, they'll refer to a previous case, but there have been some, it's usually when it's a massive change so whether I think it's things like whether homosexuality is allowed to be in a same-sex marriage. Things, big changes like that tends to be where it doesn't rely on case law.
Okay. That's nice. And what do you think about the future of this work? Which will be ultimate goal, let's say?
So what we've been working with is trying to find ways of the lawyers or users, so people who apply to the court can then use this program. We'll try and simplify some of the questions, make it easy to users so that instead of submitting this case and then it gets put into the backlog before someone generates it, they can then see how to make a good application, if you like, to the court. And they will be able to understand it a little bit better. And the court then gets better quality applications.